Good morning. Steve Holden here with Holden Litigation. Thanks for joining us again. We had a lot of interest in what's going on in the big freeze, and for good reason. First, many of you know me. I'm Steve Holden. I'm the CEO of Holden Litigation. We have offices in Texas and Oklahoma. The topic today is the MDL and the class action. And I'm going to get to that in a little bit. This, just for the record, this episode is recorded at 11 a.m. Eastern Time, 8 a.m. Pacific Time on Thursday, April 8th, 21. All aspects of the big freeze, as you know, are changing daily. We are seeing stuff in the mail. We're seeing stuff on TV about call this law group or call this seemingly innocuous company, and they will help match you with a lawyer for your claim. It is all over there. So if you have a question as we're going through here, send us the question and we'll try to get to it. We actually had several people who said they could not attend, but wanted to make sure we address certain questions. So we have several questions already, but if you have more questions, be sure to send them in. Anything that we can't, like I said, we can't get to live, we will answer versus via email or put it on our website. Next, I would like to talk to you a little bit about the big freeze. You've all heard about it, but if you take Hurricane Ike, Hurricane Harvey, and the hailstorms that cut across the southern half of Texas all the time, all of those together may not equal what is going to be the cost of the big freeze. The big freeze is estimated at 200 billion down to 20 billion. And think about this, let's just say it's 20 billion. Do you understand that the plaintiff bar will end up getting about 6 billion of that? The defense bar, my folks, will probably get $1 billion to $1.5 billion. What's wrong with that parity? But that's the way these things seem to work out. So litigation is going to drive a lot here in the very near future. Quick thought just occurred to me, Chubb just last week or 2 weeks ago made a $23 billion offer for Hartford. How do you calculate in something like the big freeze when you're buying a company, an insurance company, because they've got to have their reserves and everything for their exposures in Texas, but they're going to be there even when you buy the company. We won't answer that question today because I don't know the answer, but it is so big. This claim scenario is so big, it's going to kind of drive the litigation wagon almost throughout the country for the next decade. So now the question today is, how does Texas handle more litigation than perhaps 37 states we have all put together will not have in the next decade? Well, that's the subject today. We're going to talk about MDLs and class actions. And this is an area particularly loved by our speaker, Laura Grabouski, and I'll introduce her here in a minute. But what she's going to talk about is what type of cases should be transferred to the MDL. What is an MDL? If you've never been in a multi-district litigation, it's important to listen to this. Is the MDL favorable to insurers or insureds? I'm in the quake litigation in Oklahoma and Texas. It hadn't hit Texas yet, where they're saying the fracking caused the quakes. The very first thing we're all working on as a group that are sued is trying to get the right judge, because they got filed and there's several judges there. The one judge that is absolute worst for the defense is in the lead to get it. So we are manufacturing ways of getting that there or getting it removed to federal court. All of this is done right off the bat. It's not something that you can 2 years into it go, hey, can we move this to federal court? Hey, can we get a different judge? these are all the things that play in early, and that's why you need to know what the MDL is like for you. Class actions, what drives insurance class actions? And I know Laura's anxious to talk about that. Are class actions likely to happen out of the big freeze? Yes, but not the ones you may be thinking of. And Laura has been talking to me about that. Very, very interesting. Now we get down to the bad faith aspect. Why out of 20 billion minimum do plaintiff lawyers get 6 billion? It's a lot of it has to do with the bad faith. Bad faith is used as an anvil over a carrier's head. So they, will do what they want. The carrier will do what the plaintiff attorneys want them to do. And then they won't pay on bad faith per se, maybe, but it's still the push. So bad faith is a very integral part of this process. And I know Laura will hit it. I know that's one of the questions that one of the people that couldn't attend today wanted to make sure we dealt with. And what do past class actions MDL suggest about the big freeze? MDLs are really going to be more the issue than class actions, but Laura will explain that to you. Let me introduce you to my partner, Laura Grabouski. Laura, are you there?
Yes, good morning, Steve.
Good morning, Laura. Laura is heads our research and writing division for the state of Texas. She lives in Austin. Have you seen Elon Musk yet?
Haven't seen him yet. He's here.
He probably can't afford to hang out in your part of town. So
yes, that's it.
We're getting a lot of influx of people, mostly from California, moving in. But Laura's a 20-year lawyer. Research and writing is her forte. She actually takes a very good deposition to a very, very good expert deposition. So she's multi-talented. She runs our Austin operation. She's very, very accomplished. She has a white paper that she puts out. Now, Laura, did you put your white paper up on the website yet?
It is not on the website, but it is available on request.
Okay. All right. And it might be for listeners, it might be best if you request it, if you have a specific thing you want to see, because you may not want the entire white paper. Laura she's one of these people that enjoys this stuff, and she had a tome about everything, every section that's needed in all aspects of insurance. So you won't want the tome, you want the chapter. So tell Laura the chapter, and then if you have any questions, just call Laura. She'll be more than happy to spend 5-10 minutes with you, walking you through things. That we don't need a file open. We don't need to get a paycheck for it. A lot of things, trust me, she can answer off the top of her head. So don't hesitate to give her a call. And with that, Laura, take it away.
Well, thank you, Steve. Thanks for the kind words. And that paper was current as of 8 days ago. So I guess I'm going to keep updating it. The court's in session, legislature's in session, lots of new stuff going on. So yes, as you said, this is the perfect time to talk about multi-district litigation, class actions. They're related, but they're different. In Texas, we have the rule of Judicial Administration 13, and that is what governs the MDL. Now, the MDL was initially established to deal with a huge amount of silica and asbestos personal injury litigation. And it was really limited to those types of claims until 2003. And then it became open for additional litigation when you had lots and lots of individual suits where it just made sense to have them before one particular court. And of course, it makes a lot of sense when you have insurance litigation, because typically we call them the cookie cutter pleadings or cookie cutter claims. And of course, a lot of them arise from the same occurrence. And so Rule 13 has to apply to a civil action that involves one or more common questions of fact filed in a civil court, a district court, county court, and it has to involve the convenience of the parties and the efficient and just conduct of litigation. This is done via a motion to transfer that is filed, and it's not an elaborate motion. You file this, you make those findings. The other side may agree or likely will oppose, but you put that in the motion, and then it's handled by the court, and it's reviewed most typically by the Texas Supreme Court. Now, what do you have to show to have a finding that cases are related? The Texas Supreme Court has made very specific findings in insurance litigation that, and interestingly, you can get an MDL court even when you have bad faith claims. And in a lot of, we'll talk about this in a few minutes, with class actions, a lot of times that is a prohibition on a class action, because you have all kinds of individual treatment of, you know, my claim was handled this way and not that way. But in an MDL situation, you have these allegations of common business practices. And so the Texas Supreme Court has said that could cause cases to be related. And so you have kind of two overriding facts. You've got common storm or storms against a common insurer defendant, possibly common policies, although that does not have to be the case. And then you have common business practices and typically fairly standard claims. And why is that? Well, we have the DTPA and the insurance code, which set out the statutory bad faith, or we call them the unfair settlement claims. And those are, you know, 99% of the time pleaded just verbatim in a typical petition or complaint. Now, of course, MDL is not presumed, and so cases may not be transferred. For example, if the only fact in common is that you know, you've alleged a violation of the DTPA, or that it was an unfair claim settlement, or an across the board business practice, you've got to have kind of both of these things, that there is the same occurrence within the same reasonable geographic proximity, and there may be different types of damage. Does not have to be the same event, and does not have to be congruent. So some previous decisions, categories, again, asbestos, obviously, chemical oil spills, brush fires, but again, relevant to our discussion, hail, hurricane, and other kinds of natural storms have been found to be appropriate for a transfer to an MDL court. Now, what's the difference between MDL and class action? Well, there are obviously some big differences. Again, MDL is Rule 13 of Judicial Administration, and most of the time with the insurance claims, those are initiated on a defense motion to transfer. The class action is initiated by plaintiffs, the insureds, multiple insureds seeking to maintain a single proceeding as a class. And under Rule 42, there's very stringent criteria that have to be met when you're seeking to have unnamed, unknown potentially members bring these consolidated claims. And so the first thing is that we're familiar with these factors, right? The numerosity, commonality, typicality questions, and that the representative parties are going to fairly and adequately protect the interests of the class. And then you also have to show that the maintainability factors, that if you weren't bringing it as a class action, that there could be a risk of inconsistent or varying adjudications if they were brought separately. You can show, for purposes of injunctive relief, that the defendant has acted as a whole towards the class, and that the overriding questions of law or fact predominate over any individual questions. And specific factors to include are interest of the members of the class in individually controlling the prosecution, the extent and nature of any litigation already commenced, the desirability or undesirability of concentrating litigation in a particular forum, and just difficulties, you know, of having an unwieldy class action. And so in addition to just the major differences in the contents of the rule, and again, who's likely to bring a class action versus transfer to an MDL, what are the major differences you would see in a class action versus an MDL? Well, one very, very relevant distinction for our purposes is class discovery. This is a major driver for class action in terms of cost, and depending on which side you're on, desirability versus an adverse effect. But you've got class discovery in a class action. You've got all of the attendant notice provisions and of course the attorney's fees. All of those are factors in class discovery. Now in MDL, you'll have discovery plans, but it is not going to be the same as you would in a class action where it's just opens up because you've got again aggregate, not just single individual plaintiffs. So what drives insurance class actions? Why are they, why do we see those so often? And just recently, of course, we saw a huge number of class actions in the COVID-19 arena with the business interruption claims. Those were particularly desirable from the plaintiff's bar in terms of bringing those as a class, given that there was a single event, the COVID-19 closures, which did vary across the states, but there was a commonality there, i.e. the COVID-19 virus. The orders were similar in terms of restrictions. And then you also have a common driving factor of standardized policy forms, right? So you're going to have common questions of fact or law there, and then a big legal issue that emerged, although there are many issues with respect to that litigation. But a biggie was, of course, whether restricted access to a business or limitations on operations of a business during COVID-19 actually constituted property damage or loss of property. You have, again, a numerosity issue because you've got multiple insureds. And again, the availability of attorney's fees in insurance litigation also makes them desirable. One big issue that has emerged that we see driving class actions is litigation finance, and that has become a major driver. And in fact, with the big freeze, we're seeing that marketed, and that is just going to become even bigger. The last factor is common business practices, and that is something that we see time and again. And just as an aside, these are not big freeze cases, but some cases that are pending right now that are sought to be certified as a class. One arises out of hailstorm litigation, and this is a Dallas County case involving some public adjusters and some roofers. This is brought by insureds against their former public adjusters, and claiming a common scheme to engage with some roofers, and that they were kind of duped into assigning over their insurance claims. There are lots of different, all of the claims are different, of course, but again, what the overriding factor that the plaintiffs are relying on is that it was the same firms, same public adjusters, same attorneys who were also named as defendants, and a common business practice. Another one in the insurance arena is one that is, again, seeking certification, and this is Estes versus Allstate. Not a hailstorm or storm litigation at all. This is personal injury litigation, and this one alleges that there's a common business practice with regard to controverting affidavit experts in controverting medical expenses, whether those are reasonable or necessary. And again, the pleading, so all it is right now is a pleading, alleges that they're that the insurance company is using the same experts time and time again, and plaintiffs object to the qualifications. And so why is that potentially being brought as a class action? Well, again, numerous plaintiffs, repeat litigation, and so you've got the commonality, typicality, and numerosity factors that are potentially satisfied. So you have a situation that's just ripe for class action, and that's why we see these in our practice area.
Yeah, Laura, I'm sorry to break in on you. Is that a good breaking point, or do you need some more? 'Cause I've got.
I have more. I have more, Steve.
All right. All right. I want you to get your that stuff out there, because as you can tell, I'm anxious to get to the questions, because we got some good
Sure.
ones. Go ahead.
No, I'm kidding. But please, I'd love to hear some questions.
All right. First one, and this kind of comes up to me. Who's going to move to make an MDL? Who is going to move to make a class action?
Yeah, good question. So in the MDL, it is the cases that I am familiar with have been insurer initiated, because again, these are brought individually. A class action, of course, is brought by the policy holders typically, seeking certification, and most of the time that is opposed. And so it's usually, those are kind of the dynamics. I won't say it's across the board, and in some of the MDL there have been some where some of the plaintiffs have not been opposed at some point, but most of the time that's kind of who's driving the bus on those.
Got another question. This is from someone who was unable to attend, a friend of mine, and he said, Steve, make me look smart. when my boss comes to me and says, hey, we got all these cases in Texas, what do we got on the MDL? What do we got on the class action? What do you recommend? What are the 3 things he could say about the MDL and the class action? 3 things about the class action. So his boss goes, hey, this guy has it. He's got it.
Yes. Okay. So let me start then with, so class action. Let me give it in the context of Big Freeze, kind of what we're seeing. Like I said, kind of just in the most recent insurance coverage litigation, again, COVID-19, plaintiff's bar was all over that. What are we hearing about? Is your friend going to get a surge of Big Freeze class actions? That's not likely. Now, what it's possible, don't rule anything out, but what we're seeing is that lots of the litigation is being brought against third parties like ERCOT. They of course manage the grid. And in fact, they are embroiled in some coverage litigation. Their own carrier has filed an action about whether there's a duty to defend them in some of those claims. But in terms of direct actions against insurers, there's not a clear path here in terms of class actions. Okay. Now, with regard to MD, go on.
And I'm going to have to talk to my friend about this later, so I want to make sure I got the answers, because he's going to call me. So the first thing, if the boss says, hey, what's the odds that they're going to do a class action against us? And, he's going to say, not good because of ABC. What is the ABC? Not good, boss, because of ABC. Right.
So although okay, so, we've talked about this. The big freeze was one massive big storm, right? Which is fairly unprecedented because, as you said, typically you've got the hailstorm in the valley, ice storm in Dallas where you are, flooding in Austin where I am. This was one big storm. And so, yes, you could potentially see a class action. What we don't see though is one one big common practice, you know, or one, or in fact, that a lot of claims have been denied. You know, like with the COVID-19 business interruption litigation, frankly, that occurred because a lot of those claims were not covered. Here, this is likely to involve more covered claims. And another thing is, as you know, there's a lot going on right now in the world of appraisal. This is in my white paper, but there was a huge decision just recently where the court opened up appraisal even more. And so I suspect that more claims are going to go into appraisal as opposed to being brought as class actions.
Okay, so what I tell my friend is there's for class action, don't worry about it unless you're ERCOT or somebody else that you know, like a corporation. The carriers really don't have to worry about it much.
I think that's right.
Okay, now I don't want to get off track with my notes for him, but you mentioned appraisal. And remember that I want to come back to appraisal in a second. But so now now my friend's boss says, you know, should we look into the MDL, or are they going to force us into the MDL? What's my friend say?
Yeah, not forced. And I would tell your friend this. So the MDL has in fact been used in several other big storms. Okay, so remember the Hidalgo County hailstorms in 2012. National Lloyd's led the way to have several multiple storms brought in the MDL on those. And it's interesting that resulted in a decision by the Texas Supreme Court that there was an existing hurricane MDL. National Lloyd's said, well, I need to move all of these new hailstorms into that MDL. And also I've got a lot of other suits that, you know, are plumbing leaks and just other kind of miscellaneous things. And the court really took a look at it and said, well, look, you know, here are the standards that we've developed for these types of cases. Yes, it doesn't have to be just one county or one storm. You could have multiple storms. But at the same time, you've got to have, again, some of these overriding, you know, you have to have either one or related storms, similar type claims, and again, these standard business practices that's going to make sense to have some reason to have similar discovery. Similarly, there was other Hurricane Rita, Humberto, all of these have been ripe for MDL. So I would say carriers that are facing lots and lots of individual claims may want to consider a motion to transfer to a single court. Let me tell you something that I think is very favorable that has developed with respect to the MDL, and a big distinction with class actions. The Texas Supreme Court has said with MDL litigation, we look at discovery, we don't look at class-wide discovery. Relevant discovery for an MDL is based on the individual standard that would apply in an individual lawsuit, and that's huge. And so there have been some very favorable discovery rulings that have come out of the MDL. And so simply because you've got numerous cases doesn't mean you open the floodgates to go into the insurance company's archives and say, well, yeah, we want all your storm claim files. And so for more of those are several of these cases. They all have the same name because they all involve National Lloyd's. So if you just Google National Lloyd's or look it up on Lexis, or I can email you these cases, but very, very good for cases holding. You get your claim file. You don't get unrelated claim files, which is huge in bad faith.
Let me jump in. I represent one of the pharmacies in the opioid litigation. In particular, we have a big one in Oklahoma, Cherokee Nation. Huge, huge. It's in the MDL. Most adjusters, most claims people will know this, but if we don't force things like this into an MDL, the cost is crushing to do it piecemeal. And it's worse, you get inconsistent rulings in different courts. And then you get one court, you know, people citing this court saying, hey, this court let me do it. Why don't you let me do it? And then you get down in the valley, and folks, if you're online and don't know what the valley is in Texas, call me, we need to talk. Because that's very important in Texas. But Texas, the lawyers would love to get it down in the valley and get their judges down there to handle, you know, the individual litigation. So the MDL, in my opinion, is our friend. Is it costly? Yes. I'm going to say maybe 80% cheaper to go to the MDL to try to get it figured out. And you're more happy with the final result. Not that we win everything in the MDL and we get the rulings we want. Absolutely not. In the opioid, we fight the rulings more than anything else. I mean, it goes on and on. I think my grandkids will be finishing out opioid litigation when it's all done. I mean, it's going to take that kind of time. But what I would tell my friend is the MDL is your friend, and what you want to tell your boss is, oh, hell yeah, we're going to go to the MDL. You know, we got 10,000 claims. We got, you know, some of our carriers already have 60,000 claims, not litigation, but, you know, claims in certain counties and stuff. I mean, it is just huge. So when the time comes, the MDL is our friend, right, Laura?
Absolutely, absolutely.
I don't know. I made a ballpark guesstimate on the cost savings to go to MDL. I can tell you if we had to do an opioid piecemeal, it's easy saving 80% on just the cost. Is that figure out of whack?
No, I don't think so at all, because as you say, the discovery is streamlined, and you're in front of a single judge. I think that's huge. A single court, like you said, you don't have all of the inconsistencies. Yes, big cost savings and headache savings.
Yeah, some of these questions that I have received, we may have already answered, but I'm going to ask them just in case there's something to add to them. Question: has the MDL been used in insurance property litigation? I thought you hit it, but I want to make sure, because that's another one that's not attending.
What I will do, yes, we have talked about that, and I guess the point, but what I'll do is I'll tick off a couple of, I think, relevant cases, and I think the point is that is good to know is, again, big distinction with class actions is for class actions, you don't want to have individualized claims. And so that's when you're not going to want to bring those bad faith claims that are near and dear to, plaintiff's counsel's heart. But MDL does not prohibit those claims being consolidated. And the reason is because when they're pleaded as a common business practice, that and you've seen these, Steve, that it was an alleged pattern and practice to engage in underpayment of the claims, and to utilize certain software that might underpay claims, or to use certain third parties to minimize claim payments, or whatever the theory might be. But that has been held to be an appropriate common question for MDL purposes that might in fact preclude it from being a class action. And as I said, that you've got Hidalgo County hailstorms, National Lloyd's has been consolidated in an MDL. There's the In re Delta Lloyd's Insurance Company of Houston 2008 decision, where some defendants did not prove that the motion to transfer was appropriate, but most did. Hurricane Rita and Humberto, that's a TWIA case, 2009, and there the court also found it appropriate. So yes, there's precedent for it.
Yeah. Well, can you envision a scenario where our carriers would not want to be in the MDL. I guess if they've got only one claim in the state of Texas.
Yes, right.
We don't have any of those. We've got people that's got, the 60, 100 claims already, not much litigation filed yet. But so can you envision a situation that one of our carriers,
Well,
yeah, we
yes.
got a ton of them, but we don't want to go to MDL.
Well, here's okay. And another great point, as things develop and change, yes, things do change. So a lot of the cases that I just ticked off, what were they before? They were before the Hale bill, right? And so that legislation was 2016. What does that allow? That allows a beautiful thing called removal to federal court.
Yeah.
And so, yes, that's going to be something you're going to have to really weigh this, right? Because now post 2016, we have a lot more litigation that occurs in federal court where you've got, you've met the $75,000 or more threshold, where you've got the diversity. So I think that's a big factor to consider. So you've got to weigh it.
Well, what would you say for one of our clients that already has hundreds of thousands of claims, if you could give them the best reason not to go to the MDL? And quite frankly, I deal in the MDL a lot, and I can't think of one. But if you can come up with one reason to say, now don't do MDL, even though you got 200,000 claims. Of course, if it's not litigation yet, it doesn't matter. But let's just say there's 100,000 pieces of litigation for this one company. What would be your best reason not to go to the MDL? I want to know the answer to this one.
Well, I mean, I guess I think there's mostly reasons to go.
Oh, I agree.
I'm just saying, I would think about the, federal court. So yeah, I'm just going to caveat that, Steve.
Yeah. No, and I'm sorry, Laura, I kind of boxed you in. I don't. It really is a good reason. We can make our best argument, but it is just, in this opioid litigation, it would be so massively expensive, and the MDL is set up actually in Ohio for that one, and so folks understand, the MDL. It's kind of bringing, like Laura said, it's bringing everybody together so they can do unified discovery on unified issues, okay? And you'll get an MDL ruling that applies to every case in the MDL, no matter what state it's in. If they say, pharmacy, you've got to turn over these type of protected documents, A through F, then you do it all across the country. You can't make an argument, well, New Jersey, I don't have to, or you can make an argument. But so that is the beauty of it. You get one discovery. Now, when it gets down to the end, it's not like everybody stays in the MDL and one trial decides what everybody else is doing. That's the importance of the MDL. We can try this Cherokee Nation case, the one in Oklahoma, and the ruling doesn't have precedential effect over what goes on when the MDL passes the case out to California. Now, similar to a class action, what they do is the MDL judge does pick cases to release from the MDL to go be tried. And that the judge, MDL judge, is hoping that's the incentive, gives everybody kind of a scorecard on what's going to happen. So now we've tried, when we've tried 4 or 5 of these opioid MDL cases, then you'll start getting heavy push from the MDL judge to get in there and get the rest of them settled. We kind of have some markers. We see what's hitting and what's not hitting. So let's do it. Again, it saves the carriers about 80% on the over costs, attorney fee costs, expert costs. I mean, they just get horrendous. So you want in it. It's the defense's job to make the application. The things you do right off the bat are critical. if you misstep your MDL right off the bat, you kind of have an uphill battle. Because frankly, if you misstep and the individual plaintiff lawyers can keep you out of the MDL and they can keep you in, Hidalgo County, they're going to do it. So planning is essential, that you do it early. I don't know how much time we have left, but I do have a few more questions. And it really revolves back around bad faith. Do bad faith claims affect whether claims are brought as an MDL or a class?
Yes, and sorry.
Can you bring a bad faith as part of your litigation in both the MDL and the class action?
Yeah, I don't see them in class actions. Again, what I see typically in insurance claim litigation is you've got to stick with a policy claim. If it's a business practice, it has to be really kind of that it was a interpretation of policy to how it was paid or applied. Because that is just to me, it's a great argument on the defense if you're bringing a bad faith claim in a class. It destroys typicality and whatnot. Now, I have seen prompt pay claims, which we kind of put in the category of bad faith, but they're really not. It's the penalty interest from a late paid claim. But those claims I have seen brought. But now, in contrast, in the MDL, and we've touched on it, the courts have said, look, when it's an alleged common business practice, that all claims were handled that from the top down, that there was going to be this common practice of how we handled the 2012 hailstorms. Those can be handled together. You're alleging that they treated all claims the same way, and you want discovery of that.
Okay, let's go back, because I'm still making my list for my friend to make him look smart. He is smart,
Smarter.
but he hasn't done this type of work much. Appraisal. Now, you said appraisal is getting more use with these mass cases. How can our clients get the best use out of appraisal to avoid claims first, and then as it might be affected in the MDL?
Yeah, great question. Yes, for those who don't, I think most people watching know this. Because it was a 2019 decision that was the groundbreaking decision, a pair decision by the Texas Supreme Court that put everyone on notice that simply going to appraisal and even paying a full appraisal award was not going to end litigation of all the claims. It will, in most cases, is stop any kind of bad faith claims. But it left a big exception for prompt payment, excuse me, prompt payment interest claims and a biggie, attorney's fees. And then just very much more recently, a few weeks ago, even the Hinojosa decision said, and by the way, we meant that, 2 years ago. And so we did not carve out an exception for a reasonable payment. This was the defense that you're aware of, Steve, that had said, well, but when even before we went to appraisal, if we made a reasonable good faith payment on a claim, it wasn't the full amount of the appraisal award, obviously, but that should be a defense. And then when we later made the appraisal award all good, the court said, no, you can still then litigate, entitlement to prompt payment. So what does that all mean? It means that appraisal is being invoked more and more often. As you said, how can you be proactive on that? Well, exactly what our clients do, which is, reasonable claim handling, and adjusting, reasonable payments of undisputed amounts. The court has now told us that's not a, it's not a defense, but what does it do? It automatically stops that prompt payment interest from running. Okay. And so that right there, okay, it looks like you have a question. No? Sorry, I thought you had a question. But
Go ahead.
So that's going to stop the penalty interest from accruing. And also, again, going back to the Hale bill, I call it the Hale bill. It's now law 542A in the Texas Insurance Code that required meaningful pre-suit notice. And that's huge because it requires an insured to tell you what their beef is, right? Like, what do you think is owed? You can't just file suit and we're left in the dark as to what's the amount of your claim, what didn't we, do right, allegedly. And so you have an opportunity to, exchange information at that point. So appraisal may not even be needed. I think those are some ways to proactively address before it ever gets to that point.
I would tell our listeners, the insurance industry has a natural antipathy against the appraisal process. And I think we need to reevaluate that. It helps us in a lot of ways. It'll help us avoid a lot of litigation. I agree with Laura, although technically it doesn't, it's not a defense to bad faith. I can sure use it to help a jury understand we were doing our best, trying our best. And most policies, and Laura, correct me if I'm wrong, but most policies, it is in there that the insurance company can ask for the appraisal also.
Exactly.
And so I think that is a sign of good faith that you would want to use to do that. So before you let, ladies and gentlemen listening, before you let your carrier just automatically punt on appraisal, let's talk about it, okay? Because Texas particularly has some advantage, and we don't want to lose that advantage. Laura, that's all the questions I have. Do you have anything else, and then I'll wind up?
For one, Steve, I think I've said enough on this topic.
Well, ladies and gentlemen, Laura's fibbing to you because Laura can sit and talk this stuff all day long. When she's done, sometimes I'm just saying, Laura, okay, so what's the final answer? And then she'll give it to me. But she knows this stuff. And Laura, we really appreciate that. Appreciate having you here at the firm, carrying the load here. And appreciate you putting on this presentation. She's really the mastermind behind our big freeze defense all the way around. I mean, I kid you not. So Laura does a great job. Thank you, Laura.
Thank you, Steve.
All right. Ladies and gentlemen, we probably will have one more presentation in the big freeze. Now there may be more later as things come up. We wanted to get this in early because the MDL, like I said, has to be thought of early, and appraisal. Appraisal is something we do before the claim gets filed. So we don't want to miss out on that. So if you remember nothing else we've talked about today as to how it helps to avoid litigation, appraisal. So let's talk. And if there's a hue and cry for a full presentation on appraisal, why and how it works, then let us know. More than happy to, but it's underused. Our last presentation that we have lined up is juries. What are juries going to do in litigation involving the big freeze? That's going to be a tough one because every member of that jury, this is so pervasive, the big freeze, every member of that jury is going to have been affected by it. So we will have far less impartial jurors than we've ever had before. So we have to analyze that. And right now we're pre-guessing as to what might happen. And we've done a lot of research ourselves into the COVID and how it would affect the jury, because it affected a massive amount of people. So we have information there, and then we'll extrapolate and we will talk about how we think Texas will be affected in Texas juries, which will be quite important. So you won't want to miss that one. And with that, ladies and gentlemen, I will sign off, and I appreciate you attending, and seriously, call us if you need anything. Goodbye.